My Lord Justice U. Lalit, my Lord Justice V. Ramasubramanian, other judges of the Honorable High Court, retired judges, senior advocates and friends, a warm welcome to one and all. We have gathered here to celebrate the life and career of Mr. K. Sarvabhauman, senior advocate. At the outset, it gives us immense pleasure to welcome the former Chief Justice of India, Justice U. Lalit, who has very kindly consented to delivering the inaugural lecture today. We're also deeply honored that Justice V. Ramasubramanian is here amongst us to unveil the lecture series. To get the evening started, I invite Subhashini Parthasarthi to render an invocation.
Lakshmi Kshira Samudra Rajatanayam Shri Rangadameshwarim Dasi Bhuta Samasta Deva Manitayam Lokaikati Pangu Srimanta-Kataksha Labda Vibhava Brahmendra Gangadaram Twam Trailokya Kudumbini Sarasija Pade Mukunda Priyam Lakshmi Kshira Samudra Rajatanaya.
I now request Mr. S. Parthasarthi and Justice P.T. Asha to honor our Chief Guest, Justice Lalit. I request Mr. M.S. Krishnan and Mrs. Radhika Krishnan to honor Justice V. Ramasubramanian. I would now like to invite Mr. S. Parthasarthi, Senior Advocate, to say a few words about Mr. Sarvabhauman.
Good evening. My Lord the Justice U. Lalit, my Lord Justice V. Ramasubramanian, other judges of the Honorable High Court, retired judges, senior advocates, and friends. Thank you all very much for joining us this evening. It's a very special occasion to me personally, and a special occasion to all of us who worked under late Sri K. Sarvabhauman. I must thank Justice Lalit for so readily agreeing to inaugurate this lecture series. And I must also thank my friend Justice Ramasubramanian for being here today. Before I formally welcome our chief guest for the evening, I want to say a few words about my late father and the objective behind this lecture series. My father was born in 1929 to Sri R. Krishnamacharya, former Diwan of Pudukkottai, and Srimati Alamelu. Mr. Sarvabhauman's career in the law began in the chambers of K. Rajaya, who in those days was a doyen of the Madras bar. When my father came from Pudukkottai to Madras in 1953 to enroll in the profession, his intentions were to join his elder brother, Sri K. Srinivasan, a former junior of Rajaya. But Srinivasan had by then taken to tax work on the demise of his father-in-law, Sri P. R. Srinivasan, and had entrusted my father, a fledgling young professional, with his entire civil work. Incidentally, Srinivasan's junior Justice R.V. Ishwar is also here with us this evening. It was to Raja Iyer and Sri K.S. Ramamurthy, later a judge of the Madras High Court, to whom my father turned for assistance, and it was they who guided him in the demanding days. During that time, my father came to know Raja Iyer personally, and he assisted him in several of his big cases. In fact, he travelled with Raja Iyer and K.S. Ramamurthy to several Mufasal courts to argue matters, and it is in this capacity that he came to be acquainted with Raja Iyer, who was by then a living legend of the profession. Having been tutored by Raja Iyer and Sri K.S. Ramamurthy, Sri Sarvabhauman charted his own career path and together with Sri T.R. Mani carved out a peerless appellate side practice in the High Court. Sarvabhauman was designated as senior advocate in the year 1987, at which point Sri M.S. Krishnan, myself, and R. Shekhar, who was my father's dearest junior and who so sadly passed away, started a firm under the name Sarvabhauman Associates. A number of my father's juniors have gone on to carve out great careers for themselves. Ramasubramanian is here with us. Late Justice retired K. Sampath, Justice P.T. Asha, who is now a judge of the High Court. Others from his chambers have been recently designated as senior advocates and have been made law officers. My father continued to practice till the early 2000, that is up to 2004. And 2004 was the year our good friend R. Shekhar passed away, after which he retired to a more relaxed and spiritual life, which involved reading the Ramayana every day, but also having no cricket match unwatched. Civil law, however, was the subject in which my father practiced throughout his life, specifically on the appellate side. Now, with my own entry into the profession to which I owe everything to my father, having completed 40 years in it, I thought that the best way to honor my father's memory would be by putting in place a memorial lecture, in which distinguished speakers can speak every year and point out not only to the march of the law on the civil side, but to the general development of both the law and the judiciary and the role that the courts play in our democracy. To that end, I am especially grateful that the series will be inaugurated with a lecture by Justice Lalit. Justice Lalit has had an illustrious career in both sides of the bar and the bench. And of course, in his most recent role as Chief Justice of India, he made a stellar difference by bringing out substantial reforms despite having very little time in his office. In particular, in ensuring that Constitution bench sat and heard cases of great importance. Justice Lalit ensured that the Supreme Court performed its most vital role as an interpreter of the Constitution. I do not want to spend more time. I wish to once again thank Justice Lalit for joining us all today. I also once again thank Justice Ramasubramanian, who also we are all very eager to hear today. Thank you very much.
Thank you. I now invite Senior Advocate Mr. M.S. Krishnan to say a few words about Sri K. Sarvabhauman.
Respected Mr. Justice Lalit, former Chief Justice of India, respected Mr. Justice V. Ramasubramanian, Judge Supreme Court of India, senior advocates, former judges, advocates, ladies and gentlemen. I am not much of a public speaker. I am only used to address one person, namely the judge, and not a very illustrious group of audience. I, at the outset, thank my friend Fat Sardi for giving me this opportunity to honor my senior K. Sarvabhauman, but for whom I would not be what I am in the legal fraternity today. He was an exceptional person and a very kind person. his family, it was just not Mr. Sarvabhauman. It was the entire family of Sarvabhauman who showered affection on me as an individual. I would also like to recall certain experiences in the office which would go to show the kind of practice that they had, that is Mr. Sarvabhauman and T.R. Mani were partners, and the culture of the office, the kind of conduct that they followed in every area. And it was a revealing experience for all of us. I was initially, I was doing my ACS, and by the time I completed my law, I had completed 2 groups in ACS final. I was inclined only to become a company secretary. And my father, however, gently prodded me, saying that you should give practice a try. And I was resisting. In fact, he went to the extent of even talking to the Hindu family, which is very close to him. And I was assured of assistant secretary's post with a fabulous salary once if I fail in law. So therefore, I had to, then again, Parsardi and we were batchmates. So I asked him, because being a first generation lawyer, I had no idea of what the profession is, which branch of law I should enter. So my father first took me to Mr. T. Raghavan, doyen of the company bar, but there was no space there, both literally and figuratively. So then I said, again Parsardi was my savior. He said, why not we go and join my uncle, who is a specialist in income tax. And income tax is the area, the lucrative golden area in law. I think it continues to be. So we went there, joined his office. A week after joining the office, I went to, I don't know whether Parsardi also did it. I went to office with a t-shirt and was rightly admonished by his uncle, K. Srinivasan. Rightly so, but being a little immature and sensitive at that stage, I told Parsardi that I would like to go to a more informal office. Then promptly he dismissed me. He said, the best office for you is my father's office. It will be very nice, homely. So I walked into the office. When I walked into the office, in the corner, in another chair and table, there is another gentleman whom I knew from the pre-university days. That also gave me a lot of comfort. That gentleman also is here. He will possibly, I'll give the name a little later. No. So the surprise was, 1 month after this, Mr. Parsardi also joined our office. So I was asking him whether you also went with the t-shirt or what was the occasion. No, he said, no, Justice K.S. Ramurthy, who is my father's mentor, felt that civil law is the only area that one should practice, and if you know civil law, you know everything. So and that's how we all came together. Now, having come to, I would like to see the man, it was an office with so many juniors. The work was so enormous. We had major matters in first appeals, second appeals, small matters, transfer CMPs, interlocutory applications, and CRPs. So if I am not mistaken, the total filing on the appellate side, at the time at least when we joined, they had a filing of nearly 12% of the total appellate side filing. That was the volume of work that we had. And every junior would have the opportunity to make representations on the first day. In fact, I think both Justice Ramasubramanian and I and Parsardi had the opportunity to argue a CMP on the first day of our enrollment. That was the best thing that could happen to a junior. The courtroom jitters goes away once you get the introduction. Or rather, after the first performance, you lose fear of court. And the volume again, if you are sincere, we used to be given work, the seniors used to say, this is a client from Karaikudi, please go with him, note down the facts, and then come and instruct us. It was much before they became senior advocates. So we had an opportunity of interacting with all the clients, and we used to prepare notes, and they used to guide us. Both Sarvabhauman and Mr. T.R. Mani used to guide us. Once we finish with the client, we go into their room, we realize what are all the things that we have not asked the clients. So there comes the experience. So at every stage, you keep learning. And it was a golden opportunity for us, because in high-stake offices, you will never be allowed to meet the client, leave alone interact with the client. It's a kind of, and you will be there for 4 or 5 years without an opportunity of even appearing in court. And we were that way very, very lucky. After that, a lot of drafting. First 2 or 3 weeks, they used to dictate to us the affidavits or the memorandum of grounds. Thereafter, they used to give the bundle to us, you do it yourself. And that was the way we were able to pick up work, and we used to observe them argue, the courtcraft, and dealing with judges of different temperaments. That was an experience. I mean, before some judges, their way of arguing would be totally different. And before other judges, slightly receptive judges, it could be different. Tough judges, it will be what you call a very camouflaged way of addressing. It was all an experience, courtcraft at its best. Now, having said this is on the side of work, learning the work. But I am now on a more important aspect which every lawyer should follow, which we ought to rather. I will start with a small anecdote. Work started trickling for me after 3-4 years. I got one engagement of Karur Vysya Bank, which was an appeal against an order of attachment of 17 lakhs against a borrower. And I was instructed to engage either Mr. Sarvabhauman or T.R. Mani, whoever was free. On that day, when the matter reached, it came before His Lordship Justice M.C. Nivasan. And all of us know. And I was prepared, but I never expected him to refuse an adjournment. So I did argue, and ultimately I won. The chairman of Karur Vysya Bank was so happy that he sent his law officer to our chambers. And the first thing that he asked me was, can I have your biodata? I said, M.S. Krishnan, born on 1/11/1958, enrolled on such and such a date. That was the biodata. And of course, the most valuable thing was juniors of Sarvabhauman and T.R. Mani. And I was also empaneled in Karur Vysya Bank. 3 months down the line, the gentleman, the advocate who had referred Karur Vysya Bank to me from Coimbatore, had come to our office. He said, are you getting work from Karur Vysya Bank? I said, no. Oh, there is the regional office here. Have you gone and met the chief law manager there? I said, no, I have not. How will you get work? So immediately I went and sought permission from my seniors to go and meet the regional manager of law in Karur Vysya Bank. My senior Sarvabhauman is a little gentle. He said, no, this is not done. That was his reaction. I don't think you should go. Mr. Mani, in his typical Tenkasi accent, said, Pogalamo, President of India irundalum, our personal case in the number vittu dhaan varanum. Namba pogalamo. I was a little, I was so brash. I said, sir, you inherited such a big volume of work from Justice Ramurthy. I am a first generation lawyer and this is the first big institutional client that I am getting. And in spite of their advice, I went to meet the great regional manager. It was somewhere in, I think, Armenian state. So I gave my card. The doorman got it and then he gave it to him. When he opened the door, I saw this gentleman was reading a Tamil magazine, Kumudam. So I waited. 30 minutes elapsed and he didn't call me. So I thought possibly after the Kumudam he was a little busy with his official work. So I told the doorman that I am going now, I'll come back tomorrow. Next day, promptly at the same time, I went. There was a very big difference this time. When he opened the door, it was not Kumudam, it was Ananda Vigadan. And the treatment was the same. That was when I realized a lawyer's respect is in his chambers and nowhere else. In the moment we demean ourselves, work will come. It may take some time for first generation lawyers, but for everyone, we will get work if we work hard, and there won't be any, it's a question of time. For people who have the background of a father or an uncle, automatically you tend to inherit. Even there they have to work hard. It is not as though they can sustain the practice without hard work. So this is one very important lesson. I will never forget the advice given by my seniors on this particular issue. Likewise, it was a gurukulam for all of us. It was just not an office. We learned everything from them. We learned everything from Mr. Sarvabhauman. He would teach us patiently, he would be with us, and he will never have a harsh word for anyone. Never. And this was the way we grew up. And every duty that a lawyer is expected to, duty to his client, duty to the opponent, duty to court, and duty to the state, and not to indulge in dishonest litigation or litigation which is fomented. All these things we learnt from the temple of Mr. Sarvabhauman and T.R. Mani. And all of us are very, very grateful from what we are today is only because of these two gentlemen.
Born in 1958, Justice V. Ramasubramanian graduated in chemistry from Ramakrishna Mission, Vivekananda College, Chennai, and then studied law in the Madras Law College. He enrolled as a member of the bar on February 16, 1983, and was appointed as an additional judge of the Madras High Court on July 31, 2006, and as a permanent judge on November 9, 2009. Thereafter, he had stints as a judge of the High Court of Judicature at Hyderabad for the states of Telangana and Andhra Pradesh, and as a judge of the High Court of Telangana. He was sworn in as the Chief Justice of Himachal Pradesh High Court on June 22, 2019. He was then appointed Judge of the Supreme Court of India on September 23, 2019. Having worked in the offices of Senior Advocates K. Sarvabhauman and T.R. Mani for 4 years, from 1983 to 1987, there is no better person than Justice Ramasubramanian to inaugurate this lecture series. I request him to say a few words.
Honorable Justice Lalit, my good friends, Sri Parsarthi and M.S. Krishnan, Honorable Judges of the Madras High Court, past and present, respected senior advocates, the members of the extended family of K. Sarvabhauman, young lawyers, distinguished invitees. Mr. M.S. Krishnan started off by saying that he is not a public speaker and he is always accustomed to addressing only one man on the dais, namely the judge. In contrast, I have always been a public speaker. That is why the huge difference between me and him, he made a lot of money and I received. I always received these claps. He received something else. In fact, I was the one who was his classmate in pre-university in Vivekananda College. From Vivekananda College, Mr. Krishnan went to Shakapatnam to study BCom, engineering, and then he came back. In terms of chronology, I got enrolled on February 16th, 1983. I think M.S. Krishnan got enrolled on March 9th, and Parsarthi got enrolled on March 23rd. Correct. But it so happened that as a matter of fact, even before my enrollment in February 1983, I got introduced to Sri T.R. Mani and I joined the office. Mr. T.R. Mani was the first person whom I knew and I joined that office. But 1986, October, when they parted company and an option was given to all of us to choose the senior with whom we will go, my natural choice was K. Sarvabhauman. I don't mean any disrespect, but both of them represented two opposite spectrums. K. Sarvabhauman was not a hard taskmaster. And those days, we all like entertainment. I mean, as part of the office routine, we would like to be happy. But what we were looking for is not merely learning, but also some kind of comfort. K. Sarvabhauman used to provide that comfort. In contrast, T.R. Mani was a little hard task. He will not be harsh. But even an affidavit in support of the application for condonation of delay in representation, T.R. Mani used to be meticulous. And he would say, "Sir, who will read the affidavit, sir? Neither the judge reads nor the appeal examiner reads. Why not we write whatever we want?" T.R. Mani used to, "Is it T.R. Mani affidavit takum? What will that man think of the affidavit draft?" So, both of them represented two different. Therefore, the level of comfort, the cushion of comfort that K. Sarvabhauman provided, prompted me to opt to remain with him when they parted company. In 1987 January, I wanted to start on my own. And it was after I went out on my own that a partnership firm came into existence. And that partnership firm was originally called M.S. Krishnan, S. Parsardi and R. Shekhar. So I used to wonder that I did not know whether it happened by chance or by design. I used to tell M.S. Krishnan that probably I should have stayed in the same office because my name would have been the first name in the partnership. But it so happened that I went out and all the three of them, of course, Mr. Shekhar died a very early death, very unfortunate death, and both of them started doing well in the profession. Our seniors' love and affection for all the juniors in the office, even the staff, the remarkable. And my seniors' sense of humor, Sarvabhauman's sense of humor is something that we all really learnt. Even at times of crisis, Sarvabhauman would teach us how to laugh. In fact, if a case is about to reach and it is about lunchtime and the judge is not in a good mood because of his appetite, Sarvabhauman would call the fellow who used to strike the bell and tell him, "Arey, 1 o'clock over, strike the bell." I mean, see, he will provide lighter moments which helped us to be comfortable in the profession as first generation lawyers. He did not mind the juniors developing their own practice. One excellent quality of our senior was that in fact I don't know, the younger generation may not know, 1980s when we had no mobile phones, it was extremely difficult to get even landline connections. Landline connections, telephone connections, you have to register and wait for a long time. And it will come probably when you don't need it. So what used to happen, all my clients used to call our office phone. Our office phone And the telephone will be on the table of my senior. But without any hesitation, he will say, Ramasubramanian, there is a phone for you. Which senior will do it? In fact, I don't think I would have done it, because we will get irritated. If 2-3 calls come, it's not possible for us to maintain that poise. That was Mr. K. Sarvabhauman. In fact, the office was originally in Lloyd's Road. Then they shifted to Jagadambal Colony, 2nd Street. And I lived in a rented accommodation on the other side of Lloyd's Colony. I don't know if many of you may be aware of the topography. Lloyd's Colony is sandwiched between Lloyd's Road and Muthayamudali Street. So it was in Muthayamudali first lane that I lived. And the office was in Jagadambal Colony, 2nd Street, which branched off Lloyd's Road. Of course, both Mr. Krishnan and Parsadi will not agree if I say something now. I used to go to the office at 7:30 in the morning. They will not agree because they never came to the office at the time. So morning, my senior used to do puja for a long time. You know, we had a lot of lighter moments. Whenever a client came, he will appear on the terrace and ask me, Ramasubramanian, is he a new client or an old client? I will tell him, sir, old client. Then he will say, all right, I will complete the puja and come. In fact, in 1986, I had an occasion. All of us get foolish clients. See, if they are not foolish, why should they be our clients? So, one client wanted me to go to Hyderabad to argue an urban land ceiling case. So, he said, you can go by flight, and I had never gone by flight till 1986. So, I told my senior, I was very jubilant, and he said, sir, I have to go to Hyderabad by flight to argue an urban land ceiling case. My senior asked me, it's all right, but has he taken the ticket for you? He said, no, sir. He said, he will repay. I said, you are a fool. Say, unless he takes the ticket for you or he pays you the money, don't go by flight because you will not come back. And what was important was, he took money from his pocket and offered to pay me money for my air travel to argue my case. That was the greatness of K. Sarvabhauman. In fact, 2014 he passed away. Though he stopped coming to court after 2004, I became a judge in 2006. Then when I took his blessings, he continuously kept reading my judgments. And he was very particular. He kept in touch with law. Despite his mind actually turning towards almost Vanaprastha, the third stage of life, he was actually, every day, you can say, the Valmiki Ramayanam, the number of hours he will spend reading it, reciting it, Parayanam, it was so great. He completely turned towards God. And yet, he kept track of what was happening in court, and he used to call me very often and say, hey, you have written this judgment well. You have written the judgment well. See, he did not only encourage us when we were lawyers, he continued to encourage me even after I had become a judge. That was the noble quality of K. Sarvabhauman. And I think there cannot be a better way to perpetuate the memory of such a noble soul than by asking another noble soul to deliver the first lecture. I am not saying this for the purpose of pleasing Justice Lalit. I have been associated with, my association with him is only for the past 3.5 years. I have said this on his retirement to him personally. People may tell good things about you on the date of your elevation, not on the date of retirement. Because on the date of elevation, they are not on oath. They don't have to speak the truth, the whole truth and nothing but truth. But on the date of retirement, what they speak will be true, and that will be personally. In fact, I told him on the date of retirement, sir, because 74 days of his chief justiceship, and even before that, 1 month, 2 months before that, we started interacting very closely with each other. At least 2 months before his elevation as CJI. So I know how his career, how his life traveled during this period of about 4 months. 2 months of his tenure as CJI and 2 months before that, and even thereafter. The way he carried himself, the way he actually conducted the proceedings, the amount of time and the concern that he showed for not just making an imprint on the institution, but for developing the institution as truly an independent judiciary. I have been a witness to it. There are several things. Today, since I am a sitting judge, I can't say. But I have promised him that I will write something where you will know the real personality of Justice Lalit. On the date of his retirement, I told him, I repeat it now. After retirement, what is the problem? You see, I told him one-to-one, sir, you are a Dharmatma. You have proved to be a Dharmatma, therefore, all right, I'll stop with that. I will not tell what I wanted to say. He knows what I mean. Therefore, I am so happy that such a noble soul has come to deliver the first lecture in the memory of another noble soul. Thank you very much.
Thank you, sir. Born on November 9th, 1957, Justice U. Lalit enrolled as an advocate in June 1983. Having practiced in the Bombay High Court till December 1985, Justice Lalit shifted his practice to Delhi in January 1986. He enjoyed an illustrious career in the bar and was designated as senior advocate by the Supreme Court in April 2004. He appeared as amicus curiae in many important matters and was appointed special public prosecutor for CBI to conduct trial in all 2G matters under the orders of the Supreme Court. Justice Lalit was a member of the Supreme Court of India Legal Services Committee for 2 terms and was appointed Judge of the Supreme Court of India on August 13, 2014. Thereafter, he was elevated as the Chief Justice of India with effect from 27th August 2022. Following his retirement on 8th November 2022, Justice Lalit has continued to be closely associated with the law in his capacity as faculty at prominent law schools. We are humbled that he has so kindly agreed to deliver the inaugural K. Sarvabhauman Memorial Lecture on the judiciary and the people sustaining the trust. I now invite Justice Lalit to kindly deliver his address.
Justice V. Ramasubramanian, Judge, Supreme Court of India. Mr. Partha Sarathi and Mr. M.S. Krishnan, senior advocates, are present on the dais. The judges of Madras High Court, present and past. I see a number of senior counsel who are present here. All the persons who are associated with the chambers and the life of Mr. Sarvabhauman, ladies and gentlemen. First and foremost, I feel so privileged that I was invited to deliver the inaugural lecture. A confession is due. I did not know about the life and the activities and the achievements of Mr. Sarvabhauman so much, which last about 15 minutes or so. It is quite an impressive life journey for a person who was a counsel. If he could conduct himself as a counsel in the way it has been narrated, it's fabulous, it's something very, very commendable, and we hardly get such persons in today's life. So I feel extra privileged that yes, very well, I did come here, I have come here, and it's something which is worth my sort of visit here, that I am associated with the first inaugural lecture in the memory of such a great soul. I must say that when Mr. Krishnan narrated the incident that he went to the office of some manager of Karur Vaisya Bank, that has been the grey area where we as lawyers, we are faced with that difficulty quite often in life. And such incidents and such lessons learnt in life become the guiding light for the generations which will follow hereafter. I'll just give one instance and then deal with the topic for the day. It so happened that Mr. Fali Nariman was requested to appear in Bombay High Court on behalf of state of Maharashtra, where the Chief Minister of Maharashtra was also a party. He went to Bombay to appear in the matter, and the conference was fixed at say 6 in the evening, and the principal secretary, all of those, the IAS lobby, they came to his room saying 15 minutes before that, "Sir, we need to be there for the conference." Of course, yes. So he was expecting the chief minister to come to his room. Whereas the gentry, the brass, which was the administrative brass, they were expecting him to be there at the house of the chief minister, and that's how their protocol demanded that. And Mr. Nariman flatly refused. He said, "Nothing of the sort. If he wants me to appear in his matter, then he must come here." And that's the kind of insistence which, as lawyers, as counsel practicing law, this has been the tradition, this has been the golden rule. And this is something which must get imbibed in the young generation. Very well, now we branch off and deal with the main subject today. The subject today is the judiciary and the people sustaining the trust. I'll first narrate an incident and then deal with the topic. As executive chairperson of NALSA, I was there for about 15 months. I did a lot of what is called outreach work, galvanize people into action. The results were very fruitful. As against 14 lakh disposal on the Ini Lok Adalat in the previous regimes, which was the highest. Actually, it used to be somewhere in the region of 4 to 5 lakhs. 14 was the highest. We started getting results right from the first Lok Adalat that I took over, 28, 42, 56, 75, 95, and finally, when I demitted office as NALSA chairperson, the figure was 1 crore and 6 lakhs. So I was very, very happy about these achievements. I was chatting with my wife, and she looked at the matter from a completely different perspective. She said, "All of you are happy that you disposed of 1 crore and 6 lakh matters. So how did they get disposed of in Lok Adalat?" So I said, people compromise at some level or the other. If the original claim is say 1 lakh, in an accident matter or in an insurance matter, people compromise for about say 75, 80,000 or something lesser than that. And that is good for the institution because one matter off the docket that actually serves your purpose. Why? Because then the burden on the institution is also lesser. She said, "Are these new matters?" "No, these are old matters." So then her response was, "You chaps create a situation where the man is driven with his back to the wall. He doesn't have any better prospect in future to have his matter disposed of. and then he gets forced to settle the matter, and you call it your achievement? Absolutely correct. One view is absolutely right. So therefore, we created a situation where perhaps there were bottlenecks. He was feeling completely suppressed. There was no prospect of his litigation seeing the finality. And at that juncture, the poor fellow then steps in and enters into a compromise. That's when I realized that the trust of the people in the institution may come in multifarious sort of directions and spheres. What is the trust of the people? The trust of the people in an institution has, as I said, various dimensions. Number one, what do they expect from judiciary? They expect, number one, clarity, consistency, and definiteness in whatever you are doing as an institution. They are not bothered whether ABC is the judge or XYZ is the judge. Years back, one of the advocates who came from the interior parts of Maharashtra once told me, and he said, Uday, in good old days, my clients used to be satisfied with the decree sheet which had that red kind of, stamp, and they wouldn't bother as to who was the judge who gave the order. Today he said that people come to me with this idea, sir, get the matter listed before that court or the other court. And this he said, and that's the reflection on the kind of trust as an institution that we command. And it is that trust which has to be reposed, which has to be sort of restored completely. And that's when we have that kind of trust that we will be able to function as an institution. So roughly when we say that, yes, in every democratic country governed by rule of law, the final arbiters of any dispute or who are given the task of dispute resolution are the courts of law. So the courts of law, you recollect President Roosevelt went to the extent of saying that the real lawmakers are the judges. Because though we may say anything in the form of text of law, through the process of interpretation, they can bring in a completely different dimension or social philosophy to the nitty-gritties of those instruments of law. So that's the kind of creative ability, capacity, or the opportunity that every judge has. Then naturally in any society governed by rule of law, people would be expecting something from the body of judges. And what would they normally expect? They would expect speedy justice. Justice which is quick, fair, transparent, and qualitatively of the highest order. How do we ensure and assure that? So first and foremost, in order to maintain or sustain that trust, we must have what is called, we must look within, whether my structure, whether my apparatus is something which commands that kind of respect or not. Under our constitution, all the law judiciary, which is the district judiciary, all the postings, appointment, promotions, transfers, everything is in the hands of the High Court. The executive has no role to play, except for signing whatever your recommendations are. So who is responsible for that structural apparatus, the well-being of that, the respect and the kind of, the commanding stature that the judiciary must have? It is we alone, the high courts. Going by the law laid down by the Supreme Court time and again, the appointments to the higher judiciary, whether it is High Court or Supreme Court, is again in the hands of, principally, the judicature itself. So we are responsible for having a good structure which is manned by people of talent, men and women of talent. So first and foremost, our every action must be geared to have the best possible talent. That talent must be garnered, nurtured, brought to the court at the least possible without wasting a lot of time. The moment you do it at the speediest level, it will ensure that good talent is there, always there. And the second part, and that is where we must have the idea of independence and the idea of continuing education. What I saw is, as a person who used to go to, I still go to National Judicial Academy as a resource person. What I have found is that in the system that we follow, the judiciary, which is the Supreme Court at the top, the High Court at the level below that, and district judiciary at the lowest level, there is always a gap between two levels. The judges coming from lower judiciary are not comfortable when they are in the company of the judges of the High Court. And similarly, judges of the High Court or the lower judiciary judges are never comfortable in the company of Supreme Court. Why have we allowed this? Why have we nurtured this? Is there some kind of a babudam that we must always control that particular institution? I used to give examples, in National Judicial Academy. I would say that if a first-rate brain surgeon, neurosurgeon is performing an operation, the students who are studying the post-graduation degree level would attend the operation. Why? Because they would like the best possible mind in the profession, in that line, to be functioning, to learn from that. Have we actually provided those learning opportunities to the rungs below? We have created National Judicial Academies, but there we go as resource person, but as a continuing part of that. One organization where these kind of continuing education is the rule of the day are the defense forces. Even when a man is Major General or Lieutenant General, he still goes and attends courses. Whereas what I have found in National Judicial Academy is that the kind of judges who come there are the junior most judges. After they pass from 0 to 5 level, people stop coming to Judicial Academy. Look at the contra or the distinguishing feature. And this is where perhaps I think cohesive unit must get established. I'll give you other example. As a resource person, I was once part of the team which gave lectures to judicial officers who had come from Sri Lanka. National Judicial Academy also trains judicial officers from Sri Lanka, Bangladesh, Myanmar, Nepal, other places. So I was there, and the training was supposed to be given to the persons coming from the cadre of what is called judicial magistrates. So 15 of them were there, but they also had 4 or 5 district judges, 2 judges of the High Court and 1 judge of the Supreme Court. So I asked that judge, why is it that you are here when the training is meant only for the judicial magistrates? And that's when the reply came. So we would also like to know how you are training them. So from tomorrow onwards, it will be my task to train my own judicial magistrates. And unless and until I am party to the entire training process, how would I know? And that was a brilliant answer. I gave one suggestion to my brother judges in Supreme Court, and the suggestion was that we have these law clerks who come to you as young graduates who come there. Maybe 1 or 2 are always the law clerks working with a judge in Supreme Court, High Courts, everywhere. Why don't we have civil judges who have put in 5 years as judge, who come here by rotation as law clerks, maybe 3 months, 4 months, 6 months? As compared to the young graduate, the qualitative input that the man will be giving you will be of a different order. He will also learn from the association with you. And when he goes back to his original cadre, he'll be going back as an enriched person, as a person who has learned something with the association. Everybody learns from the association, just as 3 previous speakers actually told us about the chamber and the ethics which they learned from one chamber. So the judges who are the subordinate high court, judiciary judges will also learn from your experiences. And that's where you will have a cohesive judiciary from the top to the bottom, rather than being there 2 different steps which is without any connection. But unfortunately, those ideas are still on the drawing board. They're not getting implemented. This is when I say the structure part, now not just getting the good talent, but that good talent must also be nurtured, nursed, educated, continuing education. And that is something which we must have. Second part, as a policy, and this is where, again, that's my personal view. What happens is that, and this is exactly what we were talking just about, before we assembled for this talk. What normally happens is a judge is always in a, I won't say cocoon, but at least, in his sphere or area where he alone stands, he alone works, he alone has to deliver justice. There's nobody who can be a helping hand or an assistance coming from any quarter. That is something completely unheard of, that a judge would take input from somebody else while deciding the matter. Understandably so. He has to do everything going by his own conscience. But at the same time, there are certain areas where, as a court, you must have a practice direction. You must have a philosophy as a court. You must have some kind of line of thinking as a court. What must happen? And the moment we have any kind of uniform idea, of course there will be variations depending upon the individual cases, but the moment you have some uniform idea, the variations will be difficult and completely less, which will then lend credibility in terms of consistency as well as definiteness in your approach. What happens is today, and that's the sad part of it, that today everybody wants to take a chance before the court, because depending upon where the matter gets listed, whether it is A court, B court, C court or D court, the approach could be completely different, fundamentally different. And he wants to take that chance. The moment the body of clients, the body of citizens are aware that very well, these are matters, and this is exactly what I said, that if in matters where somebody has been arrested, unless and until there is some definite idea about investigation, perhaps the court may not interfere in matters where it's a grievous offense. Very well, you convey a particular result, convey a particular line, which will then lend credibility so far as your approach or your personality as a judicature, as an organ is concerned. And that will send good signals, because then people would not indulge in useless litigation. Why do I say so? See, on criminal side especially, when we say legal aid is required, I'm just seeing from the perspective of whatever the statistical data shows. If your 75% population or 70% population is below poverty line, and most of these persons are trapped in criminal matters, then what it means is that your profile of the persons who are dealing with criminal matters, the clients, 70% of them are below poverty line. And the legal aid which is extended to people is not more than 15 to 17%. Which means where have these people landed themselves in? Those 15 to 17%, which is the legal aid kind of, the catchment area, and 70%. Where have these 40% people gone? they had gone to the offices of some of the lawyers, they spent their resources, they sold off their properties, mortgaged the ornaments of their wife, in pursuit of what? In pursuit of perhaps useless litigation. And that's where the trust of the people will be restored if you have definiteness in the matter. And what do we normally call and what do we normally associate law of precedent with? Law of precedent is that there must be definiteness in your approach. So therefore, as a body, if you are giving out signals which are consistent, constant, clear, and definite, then you will be helping the entire community to a great extent. Because then people will be conserving their resources, people will not be taking chance of a litigation, because the moment somebody tells them, sir, if you go there, here, if the matter reaches here, perhaps you may get released on bail, and that's where the money gets spent, that's where the aspirations are getting locked, and those aspirations finally do not yield any result. And that's where the frustration in the society actually steps in. Look at it this way, that somebody said that, what is our criminal administration of justice? We have set up a machinery which is the investigators, prosecutors, which are supposed to be the cats in the society who are obliged to catch the rats. But after 10 years of pursuit, the cats then tell you, oh, the gentleman that we were pursuing was not a rat, but it was a rabbit. That's the kind of, the useless ideas that we indulge in. If our statistics show that our conviction rate is never more than 25% or never more than 27%, let us take it 30%. 70% of people are bound to get acquitted on statistical front. How many of them are under trials? So what is our approach to that then? So it means that out of under trials who are presently languishing, 70% of them are bound to be acquitted. And yet, those persons are behind the bars. And this is where the trust has to be maintained, has to be sustained, has to be achieved. And that trust will be achieved when you have a common idea. And that common idea could be that in such matters, very well, so-and-so period, and we grant bail, that's it. If you have that kind of logic, that kind of idea, the entire organ as such, the judiciary, will be giving out signals of positivity in the entire community. So the second part is, what is your approach? The third, of course, has to be when the structure is completely under your domain, your command, your authority. And any wrongdoer, any miscreant, any person who is supposed to be a dark sheep in that structure must be dealt with harshly, quickly, and sternly. And that's when if you are having that self-correction mode, then again it will give signals of great confidence to the entire population. Because nobody else has that power or command or authority to deal with what are your own people. When I say your own people, the authority lies with the High Court when it comes to district judiciary. When it comes to people above that, perhaps I think a different modality itself is put in place. Let us not get into that. But the idea is that we must be quick to respond. We must be quick to respond. If we are quick to respond, that's where the confidence will get built. Fourthly, the first interface with the society or the members of the society is normally with the district judiciary. Very few of them come directly by on the original side of the High Court, and very few of them, again, in terms of percentage, have the fortune to come to the Supreme Court. So our interface is at the lowest level. And at the lowest level, the judges concerned must be very, very positive in their approach. I have seen, unfortunately, and that is because of the fact that there have been cases where if a bail has been granted by a judge coming from the district judiciary, some disciplinary actions are also initiated against him. And that, to my mind, is you're killing the incentive on part or initiative on part of that particular person, and therefore some thought process gets developed that very well, let us not touch the matter. Let it be sorted out at different levels or different quarters rather than me taking the burden, rather than me putting my neck on the block. That kind of logic, that kind of idea must also be, that's your greatest enemy. Because the moment there is no zone of comfort for the judges coming from the lower judiciary, that's where we lose it. That's where we actually are creating a negative impact on the entire body of as the hierarchy of the judges or hierarchy of courts. This, of course, is the structural part. Now we come to the next part, how we deal with the matters in court. When we think in terms of superior judiciary, we have, over a period of time, Supreme Court has dealt with matters, has utilized, has invented, has carved out tools of great creativity. One, you have examples like, say, Bhagalpur blinding, where a committee was appointed. Another example like Sunil Batra, where 3 honorable judges of the Supreme Court went to see the actual status of the jails. So they went all the way to Tihar jail to see a personal inspection. You have various committees on EPCA side, which is on the environmental issues. There is this Environment Protection Committee which has been formed. At every level, there is a sense of creativity, there is a sense of sort of belongingness that we must do something which has always been shown by the superior courts. And that's the tremendous achievement, the positivity, which the entire population always looks towards the superior judiciary. Because they consider that this is where perhaps the solace is something which is to be found. And that's the approach which must always be maintained. Whatever be the criticism, there have been instances, I must tell you some of the instances are that where we have taken the lead, which was then followed by the legislature. The classic example is Mohini Jain and Uni Krishnan, where the Supreme Court laid down that right to education, primary education, is part of your fundamental right under Article 21. And therefore, it must be given the due weightage and due recognition and due chance. The Parliament stepped in thereafter when Article 21 capital A was inserted in the part 3 of the Constitution. What did we see in Islamic? Again, committees which are fee fixation committee and so committee, admission regulatory committee. That was the thought which came from the judicature, which is now getting translated in the statutory mechanism or apparatus. What was Madhuri Patil? Again, one idea that perhaps the determination of status of somebody must also be gone into. Now, various states have repeatedly come after the statutory mechanism or the regime. So, therefore, it's not as if that whatever has been done by the judicature in quote unquote judicial activism has always received adverse comments. It has actually been accepted by the legislature on a number of occasions. So, therefore, let us not lose that. That's a great tool which the judicature has. We must devise that, we must forge those tools, and we must go about in creating areas. That's exactly what happened in Vishaka. That's exactly what happened in DK Basu. These are examples which are, so therefore this is where the confidence of the people gets restored. That very well, even if something, there is an infirmity or there is a lacuna in some of the legislations, there is this quarter, there is this judicature, there is this particular regime which can come to our rescue. So the approach in certain matters is something which has always been, and to my mind, I'm a great supporter of the idea that the judges must not get bogged down by this idea of, quote unquote, judicial activism, criticism which has been leveled on that count. So that's where we stand so far as the approach is concerned. If you look at the level of confidence and talk to any person on the street, he'll always say that we have tremendous confidence in the Supreme Court, in the High Court, or in the entire machinery of the courts. There could be some areas of criticism, there could be some areas of exception. If we take care of those exceptions, if we take care of those criticism and come out with answers which are healthy, answers which are fruitful, answers which will solve the problems, perhaps I think we would be doing great service to the nation. And lastly, when we say judiciary, it's not just the judges alone. The lawyers as well, they are part of that administration of justice. Judges by themselves can't do anything, they can't achieve anything without the active support and participation in that entire process by the persons who are there at the bar. They are also equally responsible. So not just useless litigation to be avoided, but if we develop a culture that the matters when they are listed shall be taken up and shall be disposed of, you will actually be earning great respect from the entire population. Today, there is a feeling amongst the population that perhaps whatever is getting listed never gets disposed of. And that's why repeatedly, TV shows after TV shows, the lament is that matters are not getting listed, matters are not getting disposed of. It is true that every judge who is part of the system puts in his or her best efforts. But those efforts must also get channelized. And the channelization of those efforts will be possible if we adopt a system where the submissions made by the council are very, very brief, to the point, and not time consuming. If you conserve time, if you conserve the dimension of time, then perhaps the other two dimensions, which are your disposal and merit, will certainly get taken care of. So therefore, in the administration of justice, where the equal participation, or perhaps I think better presence, is to be allocated or associated with the advocates, the greater role demands that they must also now rise to the occasion. And if they rise to the occasion and try to conserve time, judicial time, as much as possible, perhaps I think we will have a better docket management. The moment we have that, that will always have greatest impact on the confidence barometer, confidence or trust of the people. Now to sum up, I don't think anything wrong when it comes to constitution of courts, the structure of the court, the persons who man the courts, how they are selected, what kind of selection process. We are doing exceedingly well on that front. When it comes to internal course correction, whether there is any dark sheep, how do you proceed against that? Perhaps there is area for improvement. Number two, our approach, perhaps we don't have what is called a common platform or the least possible kind of policy. When I say, I don't mean that, one must sacrifice the independence of individual judge. He or she must have that latitude, no doubt about it. But at least there must be some common approach. A common approach as an institution, as a court. It normally happens when, supposing if there is a contemptuous article, I have seen amongst the brother judges whether individual judges feel, should I take or should I not take action? So therefore, it so happens that you are in that element of uncertainty. If you are in that zone of uncertainty, then as a court, as an institution, there must be some kind of idea, very well. So far as these kind of publications are concerned, numbers 1, 2, 3, 4, courts may take action. At least something of the sort. If you have that kind of common approach, you will be taking care of many problem situations. So far as definiteness on the legal issues are concerned, that's the approach which is normally the part of your justice dispensation. That can't be subject matter of any discussion. Every judge is entitled to have his view. No doubt about it. The only thing is that matters of import must be disposed of as early as possible. So therefore, that is so far as structural part or the dispensation part is concerned. And lastly, the duty lies on the shoulders of the advocates. And today we are we have gathered here to honor one of the giants in the profession. If one of the giants in the profession is something and we want to keep the flame alive, then as persons coming from the bar, you must then have a resolution or resolve that hereafter we will try to minimize or try to be as brief as possible when it comes to submissions in court. No judge likes to shut you up, but at the same time, the judge will always be happy if you are concise, if you're precise in your submissions as lawyers. This, to my mind, is how we may sustain the confidence and the trust of people in this august body which has given us everything. This profession has given every one of you some name, fame, money, which perhaps I think Justice Ramasubramanian said that yes, perhaps the gentleman to his left was fortunate to have. So therefore it has given us, yes. That's where we must repay that to the institution. And if we do that, there will be tremendous amount of trust and confidence in the entire approach, in what we do and in what we stand for. Thank you so much.
Honorable Mr. Justice Lalit, Honorable Mr. Justice Ramasubramanian, other judges past and present of the High Court, senior advocates, Advocate General of State, and my friends. At a personal level, this is a deeply satisfying event for me. As Justice Lalit mentioned, he knew very little about Mr. Sarvabhauman. As his grandson, I too knew very little about his career as a lawyer. So therefore, this has been an eye-opening event. I'd like to thank Justice Ramasubramanian for inaugurating the lecture series. And the best lectures, I think, make us think. And Justice Lalit has left us with a lot to take home and ponder over in terms of how we sustain the faith in the institution. Therefore, thank you very much, Justice Lalit. And thank you all for coming today. And I'd like to thank my colleagues for helping put this together. Thank you very much. I now request all of you to kindly stand up for the national anthem.
जनगण मन अधिनायक जय हे भारत भाग्य विधाता पंजाब सिंध गुजरात मराठा द्राविड उत्कल बंगा विंध्य हिमाचल यमुना गंगा उच्चल जलधि तरंगा तव शुभ नामे जागे तव शुभ आशीष मागे गाहे तव जय गाथा जन गण मंगलदायक जय हे भारत भाग्य विधाता जय हे जय हे जय हे जय 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 हे